Good morning, everyone. Welcome to Old MacDonald Had a Server Farm, AIO, a mock trial.
Okay, hi, everyone. My name is Hoyt Kesterson. As you can see our title here, Old MacDonald Had a Server Farm, AIO. Last year, the mock trial was I shot a deceptive arrow in the air. So I think I'm doing some sort of childhood regression in terms of poetry, so I have to put up with that. We have the typical disclosure, but we add something on the bottom which says not legal advice. You and your counsel should probably discuss the topics. We lay our scene in call to order. I'm the Greek chorus, and so I'll be doing the laying the scene, describing what's going on. There'll be fact and expert witness testimony. There'll be legal argument from the two attorneys. And then here's something's unusual. Our judge will designate you as law clerks, and she's going to ask you what your opinion is. Unlike most sessions, we're not looking for questions. What we're looking for you to stand at the microphone and say, this is how I would rule and why. If there are questions, we'll do that at the very end if there's time. Otherwise, you have to tackle us in the hallway. And then she'll say, okay, here's my decision and why I did it. So we have this guy, Bob Flex, and he's a mighty man, but he collects dolls. And he buys pretty much every doll that Dolls R Us makes. Dolls R Us actually uses, like many companies, a cloud service, Servers R Us, and it keeps its records on there, for example, customer orders. And it does the right things in terms of security for things that have been designated secret, like it would encrypt credit card numbers and so forth. But it's never been told customer orders should be a secret, so they're in the clear, they're encrypted, so not encrypted. So there's a rascal, and he's collecting data to do whatever he can, and he will actually successfully attack Servers R Us, okay? And he will get from it customer orders and other data, which he will then copy to a location somewhere in the dark web. In other words, he's exfiltrated data. And again, that data is not protected in any way. And then he'll go on and carry on and do whatever he's doing in terms of ransomware or whatever else for this type of stuff. So there's this company called Nosy Neighbor. It uses AI, and it basically is the electronic version of what you see in the magazine rack as you go through the checkout counter in the grocery line, National Enquirer, so forth along this line. And it just collects information on public figures, celebrities, and so forth, and will answer questions about them. It is naturally out looking for information all the time, not only in its learning mode, but in its continuous data acquisition mode to present the information that is most relevant. So it does both. It isn't just learning. And it actually stumbles across, because it's out looking at the dark web, and the dark web isn't all evil and so forth. There's stuff there. And it finds records, and it actually decides to ingest these customer orders. So the aftermath, well, it analyzes customer orders and notes purchases by a guy named Ken, and data from other sources actually maps Ken to Bob. Now, he's interviewed on a live broadcast. Bob Flex interviewed on a live broadcast, and during the show, the host asks Nosy Neighbor what it knows about Bob, and it replies with all the normal, international fighting championships and so forth. But it also says Bob Flex collects dolls, okay? Well, for Bob, this is a problem because he loses macho points. The value of product endorsements, licensing, and appearance fees is lowered. Bob is, to use the technical term, pissed. So he sues Nosy Neighbor for violating his privacy. He's going to really sue a lot of people, but for this trial, we're going to compensate on this. And on May 8th, it should be 9 May, right? No, 8 May, 2024, in the Moscone Federal Court, we have a trial. You're up.
Okay. All right. Calling civil action. 24-CV-12345, Flex versus Nosy Neighbors. Counsel, will you state your appearances for the record?
Yes, Ruth Rowe for Bob Flex. Kristen Madigan for Nosy Neighbor.
And so I'm going to introduce this part of the case with the neutral statement of the case that the parties have agreed on. We've already heard from Hoyt about generally what the case is about. In this part of the trial, you'll be seeing plaintiff Bob Flex, who's suing Nosy Neighbors for wrongful use of his private information exfiltrated from Dolls R Us. We can expect to hear from 2 witnesses today, plaintiff's experts and Nosy's CEO. Just so you know what will happen today, and I do this generally for telling juries what they can expect. We'll hear brief opening statements, what the lawyers expect the witnesses will say. There'll be examination of witnesses. Both witnesses would have been called by both parties, and for efficiency, we're calling both in the plaintiff's case in chief. The parties have permission to treat adverse witnesses as hostile witnesses. The witnesses have previously been sworn. Each side has 17 minutes for lawyers to allocate as they will among openings, closings, witnesses. And after that, the matter will be taken under submission, and the court will issue a ruling shortly thereafter. Are you ready to proceed with your first witness?
Yes, we are.
All right. So why don't you call your witness?
Opening statement.
Opening statement, sorry, you're quite right, sorry, opening statements. Thank you, counsel, for reminding me. Are you ready to proceed with your opening
Yes.
statement? All right, you may proceed.
All right, good. All right. I'll come up here. Well, good morning. Reputations are easily cracked, but not easily mended. Today, we gather to hear how Nosy Neighbor carelessly shattered the stellar reputation of Bob Flex, who we also now know by the name Ken Carson. As you have heard, Bob Flex is a top athlete who competes in the cage match arena and depends on his professional warrior image to earn a significant part of his living from product endorsements and other revenue streams. He trained to stand confidently in that arena to the cheers of everyone yelling, "It's Flex time." He worked very hard, so he deserves it. But outside of work, Bob has a hobby that is important to him and has always kept secret to protect his image as a tough warrior. Bob, using the name Ken, is a collector of dolls, but not just any dolls. These types of dolls, including those fragile ones with the porcelain heads, they sit on museum shelves and are works of art. He inherited a large collection from his mother, who asked him to carry on her legacy and do this in her honor through his own collecting. And he put his trust in Dolls R Us, the only place he has bought dolls, carefully preserving his mother's legacy, ensuring that at least in this way, she would live on for years. And when he did that, he was not some famous tough guy celebrity. He was just Ken, and that was enough. He's a liberated man, and he knows collecting dolls is not weak. Unfortunately, the world doesn't always see it that way, especially when you're a cage match champion. And so Bob deliberately has always kept this part of his life out of the spotlight. It is private, and he never, ever uses his professional stage name, Bob Flex, in connection with his doll collecting. He's just Ken. So we are here today because Nosy Neighbor, like a bull in a china shop, revealed Bob's secret, breached his privacy, and shattered the life and livelihood he'd so carefully built. Nosy Neighbor did this in the most public of ways, on the type of prestigious national TV show on which Bob has appeared for years. In a split second, because Nosy Neighbor's generative AI tool, called Nosy Neighbor AI, failed to use reasonable means to protect Bob's purchase history for dolls and instead broadcast to the world the inferences that the AI made from stolen data, Bob's livelihood was destroyed. Over the last 2 years, since this incident, Bob has lost income as a result of Nosy Neighbor's failures, including the steep loss of opportunities for exhibition fights and endorsements. For example, Bob has not received any new endorsements in the last 2 years, and only half of his existing endorsements renewed, and then only at much lower rates. So here, Nosy Neighbor has violated Bob's privacy and improperly used stolen information in violation of the California Penal Code. The evidence you will hear today will show that Nosy Neighbor was indifferent to the risks that AI models pose to innocent people like Bob, and that by failing to put safeguards in place to exclude non-public sensitive information, Nosy Neighbor and its revelation of Bob's doll collecting hobby ruined Bob's career opportunities. This was in addition to destroying the Kenergy. That was Bob's passion project, continuing his mother's doll collection legacy. Today, you'll also hear from our expert witness, Dazzit Greenwood. Mr. Greenwood will tell you that generative AI is fraught with serious risks. This also applies to Nosy Neighbor AI. There are serious consequences when generative AI and the inferences it draws are based on stolen and non-public sensitive data. That's why it's so important to take preventive steps to mitigate harms before they happen. Mr. Greenwood will also tell you that he has analyzed Nosy Neighbor's AI and the facts here, and that the company fell short of the standard of care. He will tell you that it was not reasonable under the circumstances to use stolen data from the dark web and the training data used for Nosy Neighbor AI. He will also tell you that he has run tests and is confident that Nosy Neighbor AI did in fact use the stolen data to infer and reveal that Bob was Ken Carson, the doll collector. And he'll also tell you that Nosy Neighbor AI should have done a better job preserving the logs and data that led to the response that triggered the lawsuit. You will also hear from the CEO of Nosy Neighbor, Hoyt Kesterson. Mr. Kesterson will try to impress you with the sophistication of Nosy Neighbor AI and the privacy and technology measures that were built up to get this product to market safely. Mr. Kesterson will then try to shift the blame and say their efforts were good enough because they followed the advice of their lawyers and focused their implementation on ensuring that Nosy Neighbor AI did not generate answers that were defamatory or racist or sensitive. He may also claim that they don't have logs and that there's no way to recreate the environment, leading to the statement that produced this lawsuit. These are just excuses. The company developed a method to identify public individuals, including celebrities, and they developed models trained on stolen data from the dark web. Here, Nosy Neighbor did not take basic precautions to stop reasonably foreseeable harm. They breached Bob's privacy, and they did so with stolen data, and should be held accountable for the harms they caused.
Thank you, counsel. Ms. Madigan, are you prepared to make your opening statement? You don't have to use the podium. You can if you want to.
Thank you. Yes, Your Honor. Good morning. I represent Nosy Neighbor, and I'm here to tell you the rest of the story. The bottom line is people are interested in people. That's what Nosy Neighbor is, an important product using innovative new technology to satisfy a known demand in the marketplace. For Nosy Neighbor, key to our business is ensuring that our tool is aligned with human intentions and human values. Today, you'll hear from our CEO, Mr. Kesterson, all about how they have worked hard to prioritize the development of safe and effective generative AI. You'll hear that unlike its competitors, Nosy Neighbor focused its implementation on ensuring that its responses do not contain racist or defamatory or dangerous information. Working with the company's legal team, the lawyers have led the way in defining the parameters of what should be excluded when a prompt is entered into Nosy Neighbor AI. These are the reasons why people trust Nosy Neighbor as a reputable, reliable source of information and up-to-the-minute news about celebrities and public figures. So why are we here? Mr. Flex is a doll collector who bought every model from one specific store. He did so in his own name for each and every purchase. And those purchase records were not encrypted, and they were stolen in a data breach that my client had nothing to do with. The hacker made those records publicly available on the dark web. Again, actions that my client had nothing to do with. The fact that Nosy Neighbor AI drew inferences, connected the dots by analyzing repeated publicly available sources of information to link Bob Flex to the name Ken Carson and purchase records for an extensive doll collection is neither surprising nor a breach of privacy, nor a misuse of stolen information. We are confident that after you hear from the witnesses today and have considered all of the evidence, you will find that Nosy Neighbor is not liable for any breach of privacy. Thank you.
Great. Thank you, Ms. Madigan. Is the plaintiff ready to proceed with your first witness?
Excuse me?
Are you ready to proceed with your first witness?
Yeah, we are, Your Honor.
And but for context, we are in state court today operating under extreme budget difficulties. And so our lawyers atypically are sitting all in a row with the clients and the witnesses. In state court, you don't stand. In federal court, you do when you examine witnesses. And here, you can remain seated when you examine your witnesses as you choose. So the plaintiff may proceed. You may call your witness who's previously been sworn.
All right, we call Daza Greenwood to the stand.
I am here.
Hey. So please introduce yourself to the jury.
Thank you. Good morning. My name is Daza Greenwood. I'm Executive Director of law.mit.edu and founder of the civics.com consulting company, both of which specialize in generative AI applications and strategy.
And so that is what you're an expert in, and what is your expertise based on?
Over 35 years ago, I wrote my first AI application, and I've been involved in AI ever since. More recently, my primary focus has been on generative AI, working with a lot of clients in industry. I've taught thousands of professionals, lawyers and auditors and others how to use generative AI, legal and professional prompt engineering. I used GPT-4 before ChatGPT was out under NDA. I'm really into generative AI, and there you have it.
Well, could you please describe for the jury what briefly is generative AI?
Yes, generative AI, like the model used by Nosy Neighbor, are complex algorithms that are trained on vast amounts of data. And the models basically learn how to predict what the most likely next word and sentence is in a sequence. And it's almost human-like in terms of the type of cognition that it applies.
And how does it work? How does it apply that cognition?
So fundamentally, there's an input and an output. The input we call a prompt, and the AI uses patterns that it learned during training to generate a response, and that process is called inference. That's what happens after you put the prompt in and before you get the output. And essentially, the AI predicts, as I said, the most likely continuation, and it's based on deep semantic patterns of what the words are in the prompt and all of the training that it's had, including human reinforcement learning.
And what are the appropriate sources of data to generate answers?
I think the most important guidance on data for generating answers is to have adequate rights to the data. That's number one. That's adequate rights to your training data and absolutely adequate rights to the information in the prompt before you reveal it to the model. So I guess I'd be remiss as a Gen AI person if I didn't also say you want very high quality, accurate data, you want diverse data, but the most important rule is to make sure you have rights to it.
And then how are those responses then created?
The model provides a method of entering prompts that, as I mentioned, is based on inference. It takes the input and through a complex set of processes, which I don't know how deep we're supposed to get, but they're transformer layers and self-attention heads. It basically atomizes all of the words and the patterns within the language, and it can identify these patterns in high-dimensional vector space. But fundamentally, through complex processes, it identifies the patterns from the prompt to identify what the most likely natural response would be. That's known as inference.
Okay, and you mentioned prompts. I mean, what are the best practices about preserving or logging the data that are used to draw a particular inference in response to a prompt?
The best practice is to keep records of some kind of the prompts and the training data. This is really important. some logging is really helpful for ongoing usage, just for, for system integrity, but also to be able to reconstruct what happened. And also, this is advice for legal reasons, to maintain a record of what occurred. So I'd say the best advice is record keeping, documentation, and logging.
Yeah. So in your experience then, what steps would you expect a company that offers generative AI to take to make sure it does not create responses that will harm celebrities and other public figures?
So I think companies that are offering generative AI or they're using it internally, such as Nosy Neighbor, and especially those dealing with information about public figures, should adhere to established best practices and guidelines to mitigate potential harms. And from early on with the advent of ChatGPT, IAPP, for example, has been putting out great guidance on basically just applying the existing rules for personally identifiable information and other legal rules for consumer protection to the use of this technology. The same rules apply. Now we've got even more specific frameworks like the NIST AI Risk Management Framework, that's NIST 600-1. The thing it stresses is data provenance and transparency. It's sort of a fancy way of saying what I said a moment ago. Keep records of what data you have and where it came from, like when and how it was used. There's lots of privacy and security and bias detection. You could go up to red teaming and lots of stuff. But the basic, most important thing is know what you have by way of data.
And you've analyzed Nosy Neighbor AI, and what did that analysis entail?
Yes, I did. So I tried to generate the connection that Ken is Flex. And what I did with the model was I ran the prompts 1,000 times to get some kind of distribution. And it made no inference that Ken was Flex until I added the data from the dark web with the purchase histories. And that's when I started getting the connection about half the time.
So what did you ultimately conclude? Did Nosy Neighbor take reasonable precautions to prevent harm?
Based on those results, I reasonably concluded that the stolen data available on the dark web, from which the defendant sourced the data, played a significant determinative role in generating the output that revealed the plaintiff's identity as a doll collector.
Yeah, and in your expert opinion, did they take reasonable precautions to prevent that harm?
I see no evidence of that. There's no logs, there's no documentation of such precautions. I do see indications that this dark web data, this purportedly stolen data, which was used, and that would fall below the expected standards of care for this type of business usage.
Thank you, Mr. Greenwood. That's very helpful.
Thank you.
Cross-examination.
Thank you, Your Honor. Mr. Greenwood, you've told us a little bit about generative AI and how it works, correct?
Yes.
One thing you told us was that using information sourced from the dark web is not a best practice for generative AI. Is that correct?
Absolutely.
But you agree that information on the dark web is publicly available?
Sort of. It's not listed, it's not searchable, but it is accessible. I mean, the dark web's not inherently bad. It serves laudable purposes, but I think protecting political dissidents, privacy advocates, and whistleblowers shouldn't come at the expense of empowering arms traffickers, drug lords, and nefarious reputation busters.
Don't forget child pornography.
We'll never forget that.
Mr. Greenwood, you also testified that generative AI should have protections in place to prevent responses that cause harm, correct?
Yes.
But you'd agree with me, wouldn't you, that buying and selling dolls, it's not a dangerous activity, is it?
In isolation, I think the act of buying and selling dolls is not inherently harmful. In context, it certainly can be. Is the doll a weapon? Has been weaponized to harm reputation? But in a vacuum, no, it's certainly not violent or threatening.
Mr. Greenwood, you testified that generative AI makes inferences from data, correct?
Yes. In fact, you could say the very nature of it is it's an inference engine.
And those inferences can be made from many different sources of data, correct?
Yes.
You also testified that you did some testing, and you believe that Nosy Neighbor AI relied on stolen data to infer that Bob Flex was Ken the doll collector, correct?
Yes, I ran tests of about 1,000 runs, which is reasonable. That's minimum for this type of distribution. And while I acknowledge the potential for bias in any testing, I took steps to mitigate that with a diverse range of prompts and scenarios and comparing the results with and without the dark web purportedly stolen data.
But your conclusions based on this testing, let me rephrase the question, your testing that you carried out that led to these conclusions, that testing didn't occur until 2 years after the event that triggered this lawsuit, correct?
Yes, that's correct. Due to the lack of transparency and the lack of logs and documentation from Nosy Neighbor regarding their AI process and decision making, I was unable to directly analyze what they had done in the past, so I used the current model. Current models are generally even more powerful than older models, and so I think the results speak for themselves.
So to clarify, Mr. Greenwood, you don't know exactly what Nosy Neighbor AI relied on 2 years ago in a single instance to generate the inference about Mr. Carson and doll collecting that triggered this lawsuit, correct?
Correct. Due to the lack of record keeping and documentation, it is difficult to know exactly what data was in play.
Thank you. I have no further questions.
All right, may the witness be excused?
Yes, Your Honor.
All right, the witness is excused. Mr. Madigan, are you ready to call your first witness?
Yes, Your Honor.
And who do you call?
We call Mr. Kesterson, CEO of Nosy Neighbor.
All right, he's previously been sworn. You may proceed. Just a reminder, we have about 22 minutes left because this is state court on a tight budget, and our custodial, the person in charge of our custodial facilities will turn out the lights at the close of the business day. I urge you to keep to the time limits I've set previously, because if you don't, I will be unable to render my decision. But you may proceed.
Yes, Your Honor. Mr. Kesterson, please introduce yourself to the jury and state your background and experience.
Well, my name is Hoyt Kesterson. I'm a CEO. I have experience in starting companies that use technology and make money.
What is Nosy Neighbor AI?
Nosy Neighbor AI is trying to find a segment in the market. As you mentioned, people are interested in people. And we decided to basically say, well, could we build an AI that went out and looked at all this information everywhere and come up with stories, up-to-date information on celebrities, public figures, and so forth.
What protections has Nosy Neighbor AI put in place, or has Nosy Neighbor put in place to ensure responses to the AI do not contain statements that are defamatory, racist, or dangerous about public figures?
Well, that in fact was the emphasis of our work, because no one likes to be sued. And so what we did under guidance of our counsel is that we took an approach that didn't try to modify what AI was doing and would return, but we would look at the response, and before delivering the response to the person who had requested the response, we'd check to see, are we being reasonable? Are we saying anything defamatory? Are we doing bad things? Are we revealing sensitive information like medical information or financial information or something like that? We wanted to keep it, how can I best say this, friendly gossip.
Mr. Kesterson, does Nosy Neighbor AI use data from the dark web in generating responses to prompts?
Yeah, we go everywhere. We have licensing agreements with some publications and so forth, but we know there's a lot of information out on the dark web also. So we look at everything we can look at.
And just one more question, Mr. Kesterson. Does Nosy Neighbor log the sources for each and every response to a unique prompt by a user?
No, I'd like to say in the proud Silicon Valley tradition, we want to be first to market. And in being first to market, we focused on what would be the deliverable to the client, the filtering of the response and so forth. And sooner or later, we'll get to better logging, better response modifying, and so forth. But I heard references to best practices. We're more responsive to best regulations than best practices.
Thank you, Mr. Kesterson.
Cross-examination?
Thank you. Now, Mr. Kesterson, Nosy Neighbor developed a method to identify public individuals, including celebrities, using generative AI, correct?
Yes.
And you just testified that Nosy Neighbor wanted to get to market quickly, right?
Yes.
So the company put off implementing explainability, transparency, logging sources used to generate answers to prompts, correct?
That is correct.
And so when a prompt is entered in Nosy Neighbor AI, a response is generated, isn't that right?
Except for our filtering system, yes.
Okay. And your Nosy Neighbor AI decides what that answer will be, correct?
No, in reality, our filter is focused on what the answer will not be.
Ah, okay. Well, even though the responses were determined using many sources containing identical text, didn't Nosy Neighbor construct the test, often offering your own understanding?
Yes, that's the whole point. We want to be, quote, an electronic investigative reporter, just not cut and paste stuff.
So if Nosy Neighbor made an inference, such as that Ken Carson, the doll collector, is also Bob Flex, that's something your team oversaw and is responsible for, correct?
Well, our team oversaw the implementation, which on its own initiative discovered that fact, yes.
Okay, and if the inferences that Nosy Neighbor AI drew on were based on stolen or inaccurate information, your team had no way to fact check to remove the bad sources of data, correct?
Well, here's the basic problem. How do you know information is stolen? This was a ransomware attack against private companies that didn't expose information that required the owners to be informed or anything. So they pretty much kept that attack in-house, knowledge of it. We had no knowledge of it. We had no outside information that we could have said, oh, this must be stolen information, let's not look at it. And I will also admit, however, that we basically just look at information and assume it's okay. We avoid the obvious bad places, but I mean, who honestly would think that here's some purchase records of dolls, that this is nasty stuff? So we didn't put anything in the implementation to raise sensitivity.
I see. And you, Mr. Kesterson, that's a lot. There's so many things to think about. You were worried really about getting that product to market, though, right?
I was mostly worried about not getting sued, but secondly, getting into market.
Yeah. But Nosy Neighbor didn't have any traps in place to prevent the use of non-public stolen data. Isn't that right?
That is correct. It wouldn't recognize it.
Okay. Thank you, Mr. Kesterson.
All right, may the witness be excused?
Yes.
All right, you each have about 2 minutes and 30 seconds for your closing arguments.
great.
And plaintiff's counsel will proceed first.
Okay. So reputations are easily cracked, but not easily mended. Now you've heard all the evidence. You must decide the case. We bear the burden of proof. We must prove more likely than not, and we have met our burden. The bottom line is that Nosy Neighbor did not take minimum precautions when using generative AI directed towards celebrities and public figures to protect those individuals' privacy. And that private facts were revealed and then caused real damage. Nosy Neighbor was nosy, but sure wasn't a good neighbor. Instead, Nosy Neighbor created an environment that relied on stolen, non-public information and was indifferent to the consequences of that mistake. So Nosy Neighbor claims that it isn't to blame and that Bob isn't entitled to special protection for his private activities, but that misses the mark. Nosy Neighbor breached Bob's privacy and violated the California Penal Code by failing to use reasonable care in carrying out the generative AI development and product by using and ultimately publishing stolen information from the dark web as a data source and failing to have adequate protections in place to prevent the disclosure of sensitive, non-public information that harmed Bob. That negligence harmed Bob, a well-known public figure who lost lucrative employment opportunities and sponsorships as a result. He is striving valiantly to rebuild his professional brand and public image as a warrior, the man in the arena. Nosy Neighbor knew or should have known that its generative AI directed to facts about public figures and celebrities without adequate protections would disclose sensitive private information that would harm private individuals. Nosy Neighbor's minimal efforts to avoid harm are not reasonable under the circumstances. It is Nosy Neighbor who bears responsibility for carelessly exposing private sensitive information about Ken on national television, and they should be liable here. It's a terrible thing to destroy a man's reputation. You take away all he has and potentially all he's ever going to have. Bob Flex has had a great fall, and we're here to try to put him back together again and at least make him financially whole now and in the future. It's not nearly enough, but it's a start.
Ms. Madigan.
Thank you, Your Honor. Ladies and gentlemen, the bottom line here is that plaintiff Bob Flex, Mr. Carson, did not meet his burden to prove that Nosy Neighbor caused him harm, period. Nosy Neighbor did not publish stolen data. Nosy Neighbor published an inference that generative AI arrived at after analyzing publicly available, non-sensitive data. As you go into the deliberation room and think about all the evidence you've heard today, I would ask you to think about, what did Mr. Flex expect when he went on national television and allowed a broad, open-ended prompt, an answer from the world's largest generative AI tool known for celebrity news and information? He did not have a reasonable expectation of privacy in the first place. Second, there's no evidence to prove that the generative AI response that triggered this lawsuit was definitively, or even more likely than not, the product of stolen information. You've heard from one individual who ran some tests 2 years too late. That's not enough. Third and final, even if the purchase records were used, they did not contain information that was obviously harmful, obviously sensitive or dangerous in nature, such that there was no reason for Nosy Neighbor and its data collection and training implementation for generative AI to identify and exclude those records. That's what you heard from Mr. Kesterson, the CEO. While the other side's expert has claimed that Nosy Neighbor should have done more, could have done more, he hasn't told us exactly what or how. And that's because there is no generally accepted standard of care in this context. And even if there was, Mr. Greenwood can't say with 100% certainty that any failure or alleged failure by Nosy Neighbor is what actually caused the tool to reveal an inference regarding Bob's doll collecting hobby. And the fact is that inference could have been drawn from millions and millions of different publicly available sources of data on the internet. After you've considered all of the evidence, we are confident you will find that Nosy Neighbor has not done anything wrong, they are not liable, and no damages should be awarded. Thank you.
All right, thank you, counsel. The matter is taken under submission. Okay. I will be briefly in recess to confer with my law clerks about this, and I'll be back in a few minutes and to render a decision. So, boy, you, my law clerks, do I need some help here. Tough case. Because of the size of our room, I appreciate if you would give me your opinion by coming up to the microphone. What do you think? Is there a violation of Bob's privacy? Is there a wrongful use of wrongfully acquired information? Yes.
So a few things
Yes.
that I would have to, dig into actual law to kind of support. But it seems that the
Why the law, Pshaw?
it seems that implementation of privacy controls should be by the initial recipient of the data. It can't be expected that parties without a direct link to the provider of the initial data would be able to exercise privacy controls over that data. Once it comes into the public sphere, regardless of how it gets into the public sphere, if users of that data can't be aware that it was stolen, then how are they going to exercise any discrimination against the use of the data?
So interesting observation. So you're saying that in tort law, because what we're talking about is a tort, right? It's a policy issue. And the idea is that responsibility should be assigned to the person most able to avoid the harm.
Right. And that
Okay.
would be the initial collector of the data.
Okay. All right. Interesting. Thank you for that observation.
And how are you ruling? Excuse me, how are you ruling?
Oh, yeah. Guilty or not guilty?
Well, I would find no liability.
No liability.
Right.
for nosy.
Right.
Okay, interesting. All right, law clerk number 2, what do you think?
I'm in agreement as well. I believe that Dolls R Us is the one that is mostly liable for that information. Have Dolls R Us disclosed the stolen data, then I would say that Nosy Neighbor might be liable for using that data. But there are 2 metaphors I'd like to apply here that might help explain that a little bit further. If a thief steals from a bank millions of dollars, but then goes out into the street and starts throwing cash on the street, is every person who picks up that dollar, those dollars, are they thieves as well? They had no knowledge of that theft, but they picked up a dollar off the street.
Okay, interesting, thank
And
you.
then the other
That's
metaphor
good.
is like the Washington Post back in the Vietnam, when they got information that indicated that the U.S. misled people how bad things were in Vietnam. That information became publicly available. It wasn't necessarily on a search engine, but investigative journalism found that information and brought it to the forefront of the public. I think it's very similar to that as well.
Okay, thank you for those analogies. Law clerk number 3.
I just want to make the comment that Nosy Neighbor earlier noted that they were a global firm targeting data subjects across the world. So those data subjects were public figures, etc. So they must be then subject to GDPR and the AI Act if they're targeting data subjects in Europe. So if that's the case, then they've breached GDPR and they've breached the AI Act. So Bob should move to Europe, basically.
Such a great observation. You know, of course, in the absence of any, there are many, many laws that are, you know, being put forward in many states to address the issue. We haven't done it yet. In the absence of a regulatory scheme, the European model tends to be, or the Chinese model, if that's what happens in the AI context, filling, and basically will end up being, if we don't do something ourselves, the model for how we regulate this. So excellent, excellent law clerk.
But I would like to make the point that in naming structure, and the internet and everything, we have national boundaries. But when you go to the dark web, there's no national boundary.
And we do have
No allocation.
CCPA, which provides similar core rights for responsibility when you're holding personally identifiable data. So same.
Right. Although it's a little different because on the liability theories for the reasons because it's essentially a tort, it gets to be a little bit different.
But you can't get away. One thing, how would you rule?
Well, I'd rule under GDPR because there is no legal basis, and just because data is manifestly made public in Europe, that makes no difference.
Yeah.
So you don't have the right to use it, you have to have a legal basis in your article.
And so
So
guilty.
you'd rule for the plaintiff.
I would absolutely rule that nosy neighbor is wrong.
Yes.
Okay.
Okay, good. So we've got a split vote here. We'll do a show of hands at the very, very end. You, then you.
Okay, I'm going to argue that tech is a smokescreen in this case. So if a person discovered a connection by whatever means and inferred that Bob Flex is a doll collector, then the criteria should be as follows. Is the information sensitive personal information? No, it's not. Is the connection or inference true or false? Now, manifestly, it's true. Therefore, there's no slander, there's no libel, and therefore the conclusion of this court should be there's no case to answer.
Okay.
Thank you.
Thank you.
So I would say from the conclusion is not guilty, and agreeing with one of the gentlemen, I think that one is yes. Can you sue Dolls R Us, not to the nosy one? The thing is because
The deep pocket might be nosy neighbors here, right? So,
yes,
yeah.
yes. Here's the thing: is because if I recall correctly, CCPA is requiring like the company. Well, yes, there's another thing. If a nosy neighbor does use that to get a benefit of a 50K, or the focus is to collect data and make revenue out of that. Yes, that's another. Maybe can sue Well, actually, yes, right now it's the case. But anyway, I think the thing going after is that those RS is not.
And not nosy neighbors.
Not nosy neighbor at
Okay.
this point, because they are more as a providing subjective in terms of influences to say, I'm guessing, can equals the Bob in this case. But again, sadly, it's a live streaming, and for a public figure, it's definitely do the damage in certain way. But again, it's more subjective, not objective. The evidence is not sufficient to support, say, there is a strong log, there is evidence for 2 years old, and that is still, at that time, was still accurate. So I think the case, even though the lawyer was one, both of them are wonderful.
Yeah,
Make a
great
strong
job,
case.
huh?
I was literally, I'm pulling my hairs off. But I think in this way, can sue the wrong person, can sue a Bob's.
And probably in real life, they would sue different people, and sometimes people settle, sometimes they don't. They have different
Correct.
theories of liability to proceed against them. Public figures have less protection than private people sometimes, right to publicity notwithstanding. So excellent, thank you. Have another comment here. I'm being mindful of the time.
To go along with the other gentleman, this was my first point, but I decided not to raise it, was the data being in a publicly available location would have eventually made it prone to discovery by a human who would have made the same link. So to the point of the person that raised the Wall Street Journal case, if the human can't be found liable, how can a machine be found liable?
I think it varies. So you would say not guilty.
Still not liable.
Still not liable. All right, so show of hands and all of the clerks. Who would find nosy neighbor guilty? Raise your hand. Okay, and then who would find nosy neighbor not guilty? Raise your hand. All right, and because this is how decisions are made in real life in court, not guilty.
Yeah.
By claim of the law clerks, because they're doing all the real work here. Thank you all. So we had 1 minute. Anything else that anybody wants to add? Great job.
Yeah. And
Great job.
I think you're right. I mean, Dolls R Us really should be sued, but they didn't have enough assets.
This is probably wrongful use of stolen information,
Yeah.
right? The issue is intent. The bank robbery example is, if someone's dumping money that are marked bills all over the street in New York, who's going to be responsible?
Indeed.
Point, last
Yeah,
word.
I want to point out that when I wrote the hypothetical, I said they sue everybody, including Dolls R Us and
Yes.
Servers R Us. But we've already done a hypothetical on the responsibility of companies in terms of protecting information. What would be the fun of that?
It's
So
how
we took
far,
AI.
yeah, I think it's a great observation. The issue is really how far do you go in assessing responsibility? Every lawsuit is about whether you did your job or not. That's how jurors decide. They can't tell if you're lying. They can tell if you followed the rules. And when you don't follow the rules, that's when jurors will find you responsible. But they also, this would generally be a jury trial, not a bench trial. Who wants a judge to? You only want a judge if you want the judge to do the math. And Nosy would, the plaintiff would have to prove his case by a preponderance. So interesting. And jurors decide things for all sorts of reasons, and they're presumed to follow the jury instructions.
And if I may, quickly.
Yes, and Daza.
This has really shown me, it was great arguing this side of it. It served to confirm my belief that really the other side is where society's heading, and what we need to do is understand information's out there. This inference engine, this cyber intelligence is going to allow inferences at scale. We need to adapt to this new reality.
Yes, exactly. That's why I wrote the hypo.
Perfect. And that was like exactly on time. Thank you, everybody.
Thank you, guys.
The doll company didn't have the assets, but they had all the dolls, so he could have went for them after the dolls.
Thank you to the court et al. And our law clerks.
Great job.
RSA conference wants your feedback. Please consider filling out a survey.
Thank
Thank
you
you.
so much, Hoyt.